Hi, everybody. Welcome back. I hope you're all doing well and enjoying the show. If you are, please hit that like and subscribe button on YouTube, on your favorite podcast platform. Check out our website, chalkandgavel.com. You can buy some awesome merch there. You can support the show in other ways. And you can send us your thoughts and your feedback using our little questionnaire feedback form. Yeah. How's that sound? Good?
Sounds great.
Excellent.
Check out the merch. The dad hat.
The dad hat. It's a good one.
It
It's
is
a good one. All right, Chris, what have we got today?
Well, I hope you're not sick of talking about religion in schools yet, because have I got a question for you.
Okay.
Where does the contemporary establishment clause draw the line between teaching about religion and teaching religion?
Where does it draw the line?
Where does it draw the line?
There's a line?
There used to be a line.
There used to be a line. There's not a line anymore. Where the line is now is weird and scary to me. Actually, that reminds me
That's true.
that Simpsons episode with Grandpa Simpson where he says, I used to be with it, but then they changed what it was, and now it's all weird and scary to me.
That's a pretty good description of what
It
the
is.
Supreme Court is doing to
That's right.
religious jurisprudence right now.
Right? The Simpsons
Yeah.
called it. They always call it. Man.
We've got a crystal ball.
Okay, so you're going to want to pay very close attention to this one, I think. Look, you're going to want to pay
All of them.
close attention to all of them. Exactly. Because they're all very interesting topics. But this one in particular, I think this is really, really interesting. And it's interesting because this is a topic now that is sitting at this intersection of all of this religion kind of legal arguments that have been going on over the last 10 years that have started to kind of really reshape how religion and schools get together, so to speak. And so this is a case, and we've had cases like this pop up for decades, for, many, many decades. But this is one of these first cases now that is starting to wrestle with some of the more contemporary shifts in how we understand religion in schools, right?
Right. Yeah,
So-
we've dealt with these cases before, but this is the first one after Kennedy versus Bremerton, which changed the rules on us.
Yes.
It's the first one we're talking about after Mahmoud versus Taylor, which also
Right.
changed some rules.
Right.
Yeah.
And now we have the Nathan case that we'll talk about in just a second. But like there's all these religion cases that are changing the playing field. And this is a case about the teaching about religion in schools, which is something that has happened a lot for a long time. It's perfectly fine, according to the courts, to teach about religion as long as you are not proselytizing, right?
Right.
So when those cases have come up, we've looked at particular legal standards to kind of figure out how to address them. And now those standards are changing. So we're going to talk today about the case of Hilsenrath versus School District of Chathams. So this is a case about a school, a 7th grade curriculum that included teaching about different world religions, and Islam was one of them. And somebody got upset about that and filed a lawsuit. Oh, sorry. Spoiler. I stole your thunder there. But that's what this case is about. It's Hilsenrath versus School District of Chathams. All right. Here we go. Welcome to Chalk and Gavel, everybody, where we explore how the law shapes education, one case at a time. I'm Jamie Cudlitz. I'm a former middle school math teacher and principal.
And I'm Chris Thomas. I've been a high school English teacher and a school attorney. Now we're both professors of educational leadership, including a newly promoted associate professor. Congratulations, Dr. Cudlitz.
Thank you.
Forgot to say that earlier.
Thanks.
But we tell the fascinating stories connecting the courtroom to the classroom.
We do.
Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
So the kids are alright. So the kids are alright. So the kids are alright.
All right. Associate Professor Dr. Cudlitz, do you have our bell ringer?
I do, Chris. So today is all about religion in schools, and so our bell ringer is also about religion in schools. Now, at the time,
another themed episode.
Yeah, here we go. Now, at the time that this episode comes out, which is probably going to be end of June, sometime in July, somewhere around there, we are referring to the Nathan versus Alamo Heights case, which was decided in the Fifth Circuit back towards the end of April. So you may have heard about this one. This is the Ten Commandments law, but this is the Texas version. We covered the Louisiana law in episode 51. So that was right. You remember that one? That was the one. It's been a while. That was the one about the Louisiana's law that required the Ten Commandments to be posted in classrooms in Louisiana. And in the episode 51 where we covered that case, we covered the trial court decision, which was basically like that law is unconstitutional.
Right. Violates the Establishment Clause because of Stone versus Graham.
Yeah. Stone versus Graham was the 1980 Supreme Court case that basically said you can't put the Ten Commandments in classrooms.
Right. Striking down a Kentucky law.
Yes.
Did pretty similar things. Yeah.
Yeah. And so
why do I feel like there's a but coming?
There's a lot of buts coming. Maybe not a lot of buts, but one really big butt.
Okay. Yes.
So after we covered that case in episode 51, the Fifth Circuit Court of Appeals, right, heard the case and basically they decided nothing. They basically said, well, this isn't unconstitutional, but it's also not constitutional.
They basically said, we don't have enough information. Let's kick it back.
Yeah. They said they haven't really implemented the law yet. And so we have to wait and see how this actually plays out in schools to decide whether or not it's constitutional. So they issued back in, I guess, March of 2026.
A while ago, yeah.
Yeah, like pretty much a non-answer.
Right.
But it kind of signaled that, you know what? Things could start going the other way. And guess what? They did.
They did, right. That's where Nathan comes in.
Yeah, so Nathan was not about the Louisiana law. It was about the Texas law that required...
Very similar laws, though.
Very similar laws, yeah. It required displays of the Ten Commandments, the Protestant version of the Ten Commandments, the King James version of the Ten Commandments, to be displayed in every single classroom in the state of Texas. It had to measure 16 by 20 inches in size. It had to be legible from anywhere in the room and only contain that specified biblical text. You could not put any disclaimers near it. You couldn't put any sort of context statements. It's standalone biblical text.
The
on the
Louisiana one had a context statement that basically like made the argument like, hey, the Ten Commandments are important to understand American history. Like they've been very influential. Like basically trying to draw this connection between American history and the Ten Commandments, right? And Texas is just like, nah, we're just going to put the Ten Commandments up.
Yeah. Okay. Now, just keep in mind, there's a lot of other laws that have either been proposed and died in other states, but other laws that have been implemented, like, Alabama signed a law recently that did that. It included the context statement, and it only required the Ten Commandments in, I think, civics classes in grades 7 and above or something like that. So there are various forms of this law, these kinds of laws floating around the country. A lot of them have been struck down. But the Fifth Circuit in Nathan, and the Fifth Circuit governs Texas, Louisiana, and Mississippi, right?
Sure.
Excellent. So the Fifth Circuit looked at Texas's law and actually ruled on the merits. They said, you know what? We are going to decide whether or not this is constitutional. And, you know, if you hadn't already guessed, they decided it's perfectly fine.
Right. Yeah. They decided it did not violate the Establishment Clause.
Yep. Which is a reminder, the separation of church and state clause.
From the First Amendment. Right.
Yeah. So basically their argument here was they said the Supreme Court in Kennedy versus Bremerton struck down or effectively gutted the Lemon test, which has been, we've talked about it on the show, the test that we have used for the better part of 50 years to help us decide what is appropriate from a religious standpoint in schools, right?
Mm-hmm. And not just in schools. It is every Establishment Clause
government
question from like the 70s until Kennedy versus Bremerton. So like it was all Establishment Clause jurisprudence.
Right. And it had 3 questions. All right. And if you couldn't answer, you know, like if you've got any of those questions wrong, then they kind of generally said, okay, that's going to be a violation of the Establishment Clause.
Right. That's a violation.
Right. So it's got to have whatever is in question, the law in question or whatever, it's got to have a secular purpose.
Right.
Right. That's one thing. So the reason behind the law can't be a religious one. Okay. The second prong is as many times as it takes me 5 minutes to remember what the second prong is. Every time I do this.
We've done this, you know, a number of times.
Right. The third one is excessive entanglement, right? Like it can't create too much of a entanglement between the government and the church, right? And the second one, it can't favor, I always remember, it can't favor one religion over another or disparage a particular religion, right? That's kind of the best way to sum up the 3-prong test, right?
That's the gist of it. Or it can't favor religion over non-religion.
Right. Okay, right.
Or vice versa.
Right. So that was the Lemon test. We've been using it for better part of 50 years. And in the Kennedy versus Bremerton praying football coach case that we covered way back when we began the show, with a couple episodes back then, they have effectively said the Lemon test is not really a good test anymore. We're going to think about history and tradition instead.
Right.
So what does that mean? You know,
that is a good question.
That's a good question. And the Fifth Circuit started to answer that. So the Fifth Circuit basically said, okay, so they tossed out the Lemon test in Kennedy versus Bremerton. So that effectively rules or effectively leaves the Stone case dead. All right. Because Stone relied on the Lemon test.
Right. And if you take that logic to the extreme, that means that every Supreme Court case, even mentioning the Lemon test between 1973 and 2022
is
now called into question.
Yeah. Yeah.
And that is massive.
And it's interesting though, because the dissents in the Nathan case, one of the things they said is, hey, you don't have the authority, circuit court, to render a Supreme Court decision null and void. The only people who can do that are the Supreme Court. Right.
Which to me, like, is a very strong reason why the Supreme Court might take Nathan up.
And it's going to get appealed to the Supreme Court.
For sure.
You know,
it's a question of like
whether or not they take it up. Yeah.
Yeah.
So anyway, they said, listen, you know, Stone is dead. So the governing legal principle behind the 10 Commandments in classrooms, this Stone case is, you know, forget about it. So let's look at history and tradition. And basically what they said was, what were the founding fathers thinking of when they established the country and they were talking about the separation of church and state clause in the Constitution?
What did an establishment of religion look like
to them
at the time of the founding?
Right.
Yeah.
And so basically what they said was, look, they were getting away from England, and England had a state church, right? And if you didn't go to church on Sunday or whatever, that was a problem from a legal standpoint, right? And your taxes went to the church, and you were, if you didn't pray, or if you didn't kneel, or if you didn't do what you were supposed to do from a religious standpoint, there were penalties for that, right? And
Right.
that's kind of that's what this court looked at and said, all right, are the 10 Commandments doing any of that?
They said no.
They said no. So there's nothing wrong with them.
Right. Yeah, it's a very narrow way of understanding the Establishment Clause.
Very compartmentalized and very historically constrained, right? Like,
Right.
we don't care about any context outside of what we think the founding fathers
Right.
intended.
Well, and that's a huge issue because these justices are not historians. And I've said it before and I will say it again. Like,
Please.
they are amateur historians at best. And
Right.
as with any of these things about historical practice or understanding, like, it is one of those situations where you can kind of just look over the crowd and pick out your friends to support whatever conclusion you want to get to.
Mm-hmm.
And that is a massive problem when it comes to legal decision making.
Right. And, this was an en banc decision. I mean, I don't know how many justices there are in the Fifth Circuit, 15, 16, something like that.
Some dozen, somewhere around there.
Yeah. Well, no, I think there was,
Dozen plus.
yeah, I think a dozen plus, because I think there was 9 that voted, or 9 in the majority, and maybe 6 or 7, or I don't know. It was,
That feels right.
yeah, it wasn't, like if there's 15 of them, it wasn't all 15 that said this is
Right.
the way to go, right? Like,
Yeah.
Anyway, so, we went into a little bit more detail in this bell ringer than we often do, but I think that's important context for the discussion that we're going to have in this, in
Right.
in today's case.
It sets
right?
up this case perfectly.
Totally. So anyway, that's the Nathan decision. We have in our show notes, we've got a link to a great magazine called Law and Policy in Schools, which is a great practitioner-focused magazine that Chris and I are both a part of. And in the current issue that is out right now, there is a big feature spread on the 10 Commandments. I wrote a piece in there. Dr. Martha McCarthy wrote a piece. So, this is big stuff that's happening right now. And we're going to kind of talk today a little bit about another case that is going to be wrestling with a lot of the same
Right. Yeah.
issues,
Stepping
right?
away from the 10 Commandments and stepping into teaching, explicitly teaching about religion.
Yes, exactly. So, like we said at the top, this is the case of Hilsenrath versus the School District of Chathams, which sits at the intersection of all of this stuff we've been talking about, okay? And we thought that all of this stuff seemed settled, as we said. But this is going to be one of those cases that everything that's happened in the last 5 years kind of makes us question how all of this stuff is going to function in schools moving forward, right?
Right.
Okay. So our story today starts in the 2016-2017 school year. CH was a 7th grade student at Chatham Middle School, which is in New Jersey. It's maybe about 45 minutes west of New York City. And like all 7th graders, CH had to take a world cultures and geography class. Okay. Very standard curriculum for 7th grade.
Yeah.
The class covered world religions to help students, quote, gain a greater sense of the world around them and become active and informed global citizens, unquote.
I love it. I'm
Okay.
here for it.
This also implemented state curriculum standards that required that students be able to, quote, compare and contrast the tenets of various world religions, unquote. All right.
Okay. So this isn't just a district class. This is a statewide, like,
Yeah.
hey, these are the standards you have to teach.
Yeah, statewide.
School districts in New Jersey, go teach about comparing and contrasting world religions.
Yep.
Okay. So these school districts don't necessarily have a choice.
No, that's what they got to do. They've got to meet that standard. So the class was organized into 7 units, and 6 of the units focused on a different region of the world. And within each of those regional kinds of units, students would learn about the history, the culture, and the religions of that particular region. Okay?
Sure.
That kind of makes sense. So when students studied Latin America, they learned about Christianity. When they studied East Asia, they learned about Buddhism and Hinduism and, and all that stuff, right?
Sure. Yeah.
You see where this is going?
It's a survey class, so you've got to be like, I'm not sure exactly how far the history goes.
Right.
Or if it's just looking at contemporary cultures.
The last few hundred years, or
I don't know.
Who knows?
That's actually probably a good question.
Who knows, right?
Yeah.
The point is, they studied pretty much, maybe not everything, but they tried to study a broad spectrum
Right.
of what goes on in different regions of the world. And
Right.
religion is a huge part of that, obviously, right?
Right. And there's a ton of pluralism, but you got to pick the big ones or the majority religions, whatever it might be,
Right.
in these different areas. Yeah.
Right. So you know where this is going?
I can guess.
So they study the Middle East. All right.
Of course.
And so there was a unit on the Middle East and North Africa. And in that unit, students learned about Islam.
Okay.
All right.
Just like they learned about other religions in other areas.
Exactly. And in one activity, that activity was titled, quote, Teaching Critical Thinking, Making Generalizations with Content, unquote.
Okay.
That seems,
I like critical thinking.
yeah, it is a good thing.
Mhm.
It's a good thing. So in that unit, students were asked to evaluate a YouTube video titled Intro to Islam to identify and assess the validity of generalizations that were made in the video. Okay. The video included a series of questions and answers about Islam, including, what is Islam? Answer, faith of divine guidance for humanity based on peace, spirituality, and the oneness of God. Another question, who is Allah? Allah is the one God who created the heavens and the earth, who has no equal and is all powerful. Who is Muhammad? What is the noble Quran? What does history say about Islam? So a lot of
Right.
different questions and answers to kind
Yeah.
of give viewers a sense of what this religion is about. What do they believe?
Okay. Yeah. And that's all very standard stuff if you're learning about a religion, right? Like
Seems
you're
to
learning
be.
about how people from that faith understand and,
Yep.
view their religion and its teachings and its practices.
Right. Right.
Yeah.
So they also had to, as another part in the unit, they also had to learn about the 5 pillars of faith and the impact and significance of them in the Muslim culture. In that lesson, students were given a broad overview of Islam, including the symbol of Islam, key figures in Islam, the Quran, demographic statistics about Muslims, and a summary of the 5 pillars. The slides for that lesson also included a hyperlink to a YouTube video entitled The 5 Pillars of Islam, which showed an animated conversation where a non-Muslim boy asks a Muslim boy a series of questions about Islam. In that video, the Muslim boy says, Muslims believe there is only one God whose name is Allah and who is the creator of everything, unquote. Right? And then the video closes by providing an email address and a website where folks can get more information or, learn how to visit a mosque or something like that, right? It's important to note here that students didn't watch this video in class. It was linked in one of the slides that they had to review, and that was hosted on the class's Google Classroom
Okay.
Drive.
So it was available to them.
It was available to them, and they could click on the link and go see the video. They had different activities where they had to demonstrate their understanding, which is a very common practice.
I was going to say, all of this is feeling very standard.
Right? Yeah. Like, okay, you've learned about all of this stuff. Now tell me what you learned, right?
Right.
I want to make sure that that this is kind of what we do in school. Right? And So like there was a worksheet that, like with fill in the blanks, and it said things like, okay, pillar number 1, the basic statement of the Islamic faith is there is no God, but blank and blank is his messenger, or something like that,
Okay.
right? Like just fill in the blanks, right?
Yeah.
You watch the videos.
I can fill that in based on what we've talked about so far in this episode.
Right. So everything that's great. You know, as we said, learning about religion, all good, no problems. Everybody had a happy time, right?
Yeah.
Of course.
Always. If we're talking about it.
Yeah.
One of these days we should do a case where there isn't a
We're
lawsuit.
like, that's the end.
And just be like, and everyone went home and they resolved their difference. They resolved their differences amicably.
Yeah, those situations, I think they'd put us out of business. Right?
I wouldn't mind it.
No, it's time to retire. Let's retire.
Right? Yeah. Let's work ourselves out of a job, Jamie.
Yeah, I'm okay with that. All right. So CH, we're back to CH here. They watched the video on YouTube. They watched both of the videos on YouTube at home with his mom. Okay. And the mom's name is Libby Hilsenrath. She saw the videos. I don't think she liked what she saw.
Right.
Because she emailed the administrators and expressed concern about the curriculum. And then she aired her complaints at a school board meeting in February of 2017. Now, from the digging we've done, I think we get the impression here that from this and other school board meeting minutes that she might have been a frequent flyer there at the school boards.
Right.
But it's hard. It's hard to know if that frequent flying started before this event or after, was solely about this. But you know, her name
was this the inciting incident?
Yeah. Her name came up as a regular attendee.
Good. Engaged in local government.
Yeah, it's right.
You'll love to see it.
Which is great. So anyway, at another meeting later on, the board defended its curriculum, but they said, listen, okay, this is causing some disruption, so we're going to take the YouTube links out from the PowerPoint slides. Okay, we'll make that concession. We'll take those YouTube videos out, leave everything else.
Right. School has a little bit more control over what and how they say things if they're not citing external sources. Sure.
Right. So again, everybody went home happy, right? Hilsenrath was like, oh, okay, thanks. I appreciate you listening to me. Have a great day.
Yeah, sure. She was so happy she filed a lawsuit. Because that's what I'm doing when I'm feeling good.
When you file lawsuits?
Yeah, just willy-nilly. No. No. Lawsuits are annoying.
They are complicated. They are annoying. And what happened in this one?
Lots of stuff, actually. This one was particularly annoying because this one was working its way through the system at the same time that Kennedy versus Bremerton was working through its system. Yeah. And so the trial court basically had to do this case twice because so mom here is claiming that the curriculum on Islam violated the Establishment Clause of the First Amendment. She wants an injunction. She wants a declaratory judgment saying like, hey, you can't teach that.
Did she say anything about the other religions that were being taught?
No, it was just an objection to teaching Islam. As far as I'm aware. Okay. I haven't read the complaint, but just from the opinion, it's just focusing on Islam.
Interesting.
Indeed. But so, yeah, the trial court had to do this case twice because it decided this case based on the Lemon test. And it said school wins based on the Lemon test. And then it got appealed. And during that appeal, the Supreme Court decided Kennedy, kicked it back down. So this is one of the first examples of a court grappling with the Supreme Court killing the Lemon test in Kennedy versus Bremerton in favor of the historical analysis test. Now, in this case, that didn't change the outcome. So the school district still won at the trial court both times.
Okay.
But that's why this case has been going on, for 8 years, I think, at the point that this decision was made in 2025. That's a long time to litigate one case.
Yeah, totally.
And then there's another thing that I think is also really fascinating about this case, given the timing, and we've already kind of alluded to this. Mom only brought, or at least the court at this point is only deciding an establishment clause claim. There's no free exercise claim. Right. So, that's what was at the issue in Mahmoud versus Taylor, because that was a free exercise complaint for a parental right to opt out.
Yeah. So basically, she's not saying teaching about Islam is impeding my ability to raise my kids based on, like, I feel a burden on my own religion.
Right.
Okay. Which was kind of the Mahmoud side of things. And where the court said, yeah, you know what? You're right. If something's going on in school that makes you uncomfortable from a religious standpoint, that could potentially be a burden on your religion. So you've got the ability to opt out of that. She's not going there with this one. She's going to the establishment clause, just saying, hey, school, what you're teaching is wrong because you're not supposed to be doing anything religious. I'm oversimplifying, but yeah, that's exactly it. Because under the free exercise clause, it's an individual argument, right? Like it's hey, this violates my right to raise my kid in my religious faith, right?
And the Supreme Court in Mahmoud said that if what the school is doing substantially burdens that parental right to raise their child within their faith, that could justify an opt out for that child. The establishment clause argument is basically saying, school, you are violating the Constitution by teaching this to anybody and everybody.
Right. Yeah.
So, in Mahmoud, they basically said, like, we're just asking for a personal opt-out. We're not trying to change the curriculum. Here, the establishment clause argument is we need to change the curriculum.
Fun fact, side point. The Texas law that we talked about before, there's no opt-out policy for that.
How would you?
In fact, it's impossible.
Right.
Like it's in every classroom. Right. So if you think the 10 Commandments are going to burden like if you're Buddhist or a religion that doesn't necessarily subscribe to that or has a problem with the King James version of the 10 Commandments up there, you've got no recourse.
Which raises what I think is like the most interesting question from this case and the 10 Commandments case, which is like, how do you put these things together?
Yeah.
Right. So is there curriculum that is fine under the establishment clause? Like it says, hey, this is not an establishment of religion. You can keep it in there. But that parents could not opt out of under Mahmoud.
Well, so the 10 Commandments law, apparently.
Well, but they didn't raise that. No one has brought a free exercise complaint saying like, hey, Texas, you're violating my free exercise rights by having the 10 Commandments up there. Right.
Yeah.
And that case is going to be so interesting. And so
because of what you just said. Exactly.
Right. Like, is there curriculum that is cool with the establishment clause, but that doesn't rise to the level of a substantial burden to justify an opt-out? So like, is the right to opt out so broad that once the establishment clause lets it in, Mahmoud lets parents opt out? Or is there like a band of curriculum in the middle that is okay by the establishment clause, but doesn't trigger an opt-out? And I think this case here is actually a really good test case for that. So I know Mom only brought an establishment clause claim, or the court only addressed an establishment clause claim, but I'm gonna bring in some Mahmoud here because I think it's really interesting to think if Mom had brought an opt-out claim,
right, would
she have been allowed under Mahmoud to opt out of teaching about Islam?
My gut says absolutely,
and my brain says maybe not.
I know.
So let's talk about it.
No, I mean, but like my gut says absolutely because of how they described what their reasoning was for, like, if you could apply Mahmoud in its purest form, maybe, or like, I can't see how you could make an argument for, you know what, these two things are totally different, right?
I mean, I can make that argument. Do you want me to make that argument?
Make it. Let's hear it.
Yeah. So I would love to make that argument because I think, like, I think this is one of those situations where there might not be an opt-out, but it depends on how you interpret Mahmoud.
Right.
And the meaning of Mahmoud, the case, is very much unsettled right now. And actually, like, we saw this in Mirabelli, the case we just covered a few episodes ago, about like the trial court basically said, or the appellate court said, like, Mahmoud doesn't really deal with, or has nothing to say about California's law or policy that prevents schools from notifying parents about children's gender identity at school. And then the Supreme Court got it on the shadow docket and said, you guys are totally misapplying Mahmoud. Mahmoud totally applies and actually controls the thing here. And so, like, the meaning of Mahmoud very much matters. But I'm going to go back to the text of the decision in Mahmoud.
Okay.
I'm going to make an argument based on the text because I know Justice Alito really, really likes that. And he wrote,
well, because you guys
decision.
are buddies. Yeah.
Yeah. Right. So the standard in Mahmoud is that you can opt out if a policy or practice substantially interferes with the religious development of your child. Right. So that substantial interference is the standard. And the court says that that's a fact-intensive inquiry. And here's some of the things that the court tells us to look at within that, broader context. You got to look at the specific religious beliefs and practices that are asserted, the specific nature of the educational requirement or the curriculum at issue.
I see where you're going.
Whether it's targeted towards very young children, and whether or not it's presented in a neutral manner or in a manner that is hostile to religious viewpoints, and designed to impose upon students a pressure to conform.
Yeah, that's the thing.
Right. So if you read Mahmoud, that it's not just does a parent object to this? It's a question of, like, is this a substantial interference on their ability to raise their child? So it's a content plus context test.
Yeah.
So what is being taught to whom and how is it being presented?
Right. Yeah.
So apply those here.
Yeah.
I think you can come out the other way.
Yeah.
The family here isn't pointing to any particular religious beliefs other than the fact that, it's just a different religion that has different beliefs than their own. It's a curriculum requirement from the state. So it's not just something that the school district decided to do on its own. It's part of the curricular standards. So, it's very much part of the formal curriculum. And it's about learning about and comparing various world religions. There's lots of different religions in there. So it's not just picking and choosing which ones they want to teach. It's for a middle schooler. So, a little bit more advanced, less impressionable, more able to think for himself. And, some of the material is communicating what adherents of Islam believe, but the material itself is presented in a neutral manner by the teacher with no indication that either in purpose or practice, it's intended to change students' belief. And that was a big sticking point for Justice Alito and Mahmoud.
Yeah.
He basically said that these books are expressly normative. They're making normative value judgments that in some ways denigrate people's beliefs. So I think you could take all of that and you could say, hey, this isn't a substantial burden. No opt-out.
I see that. But then I also see the potential problematic nature with that particular argument with respect to, say, the Ten Commandments law.
But if you apply the factors to the Ten Commandments law, it's in every public classroom, so K to 12.
Yeah.
And it's not part of the curriculum because it's in classrooms that are completely unrelated to religion, or if you're taking Louisiana's tact, the influence of Ten Commandments on history.
How is something, this is a little bit more philosophical.
I love philosophy.
Okay. But if you are forcing something to be up on a wall in every single classroom in a state, how can you claim that that is not part of the curriculum?
Well, I don't think they are claiming it's not part of the curriculum.
No, isn't that what you just said? It's not part of the curriculum?
Well, I'm saying it's unrelated to curriculum standards, and it's unrelated to what is being expressly taught in those classrooms.
Yeah, but this is where my philosophical point goes. Expressly taught versus implicitly taught. It does not mean, like, you go into a school and
Oh,
Like,
right. No, I'm not saying that
what's
the Ten
happening
Commandments
there.
aren't being taught. I'm saying that they are not part of the express curriculum and therefore don't deserve as much protection.
Oh, I see what you're saying.
So like, if I'm in a French class, I can justify teaching stuff related to France.
Yeah.
I can't justify
yes.
teaching the Ten Commandments. So therefore the context is much weaker to, I guess, require the Ten Commandments in a French class.
Right.
is what
Okay,
I'm
so
saying.
we're talking about the same thing, but in two different ways.
Right.
I think I was just basically saying that argument that you're making based on your reading of Mahmoud, which I fully agree with, it makes how we handle the Texas Ten Commandments law potentially problematic.
Right.
Like I feel like it's
Could
much
you opt
harder.
out of the Ten Commandments law? Yeah.
Yeah, like it's much harder to basically say,
Is the line between teaching Islam and the Ten Commandments in every room, or do they both fall on one side of the line or the other?
right,
I think there's a way to draw the line between the two,
you do.
where you could opt like the Ten Commandments in every single classroom. And again, it's every single classroom,
Right.
K to 12.
Yeah.
I think that is a stronger case for an opt out
Oh,
than
me too.
the Islam teaching Islam.
No, I completely agree. I think I can see how Mahmoud could potentially allow for an opt out in the Islam case, potentially.
Right.
Okay.
I mean, I think it all depends on how broadly you read
Right.
Mahmoud. There's absolutely a reading of Mahmoud
Right.
that says, like, we're not going to be too stringent about questioning what parents say substantially interferes.
Right.
And if that's the standard, if the substantial interference is a low bar, then yeah, both of these things could fall on the side
Yeah.
of
I'm not saying I agree with it.
right. But these are the questions that we're going to have to grapple with because it's a line drawing issue, and
Yeah.
the Supreme Court is not giving us a lot of direction on how to draw those lines.
Yeah, no, they're just saying.
I think there's a lot of interesting stuff happening here.
Yeah, I mean it's and listen, we've had these kinds of cases over and over again. I think it was Wood versus Arnold, which might have only been a few years before this one. Was another case about pretty much the exact same thing. I think it was in a high school,
Right.
instead of a middle school, but it was teaching about Islam, and the court basically said,
Right.
there's
But-
nothing wrong with this,
That was based on the Lemon test.
which was based on the Lemon test.
Right. And now, yeah. So let's pivot to the Establishment Clause question that the
Okay.
court actually decided.
Okay, based on history and tradition now, not the Lemon test.
Exactly.
Okay,
Right.
so are we paying our taxes to pay for this religious?
Well, and that's right. Like that's pretty much and the courts are all kind of playing from the same playbook because the Supreme Court kind of I think one of the concurrences to one of the cases cited some influential law review articles that kind of, tried to lay out the historical understanding of what an establishment of religion meant at the founding.
Yeah.
Now, importantly, the Establishment Clause says that Congress shall make no law respecting an establishment of religion. And I think it was Martha McCarthy, when we had her on the show, talked about like, it's not just about establishing a religion, it's about laws that respect an establishment of religion. So like the line is much further away from respecting. So anything that like moves us closer to the government formally endorsing a religion, Martha made the argument that like that is also problematic under the Establishment Clause. So like, again, it's another line drawing issue.
Yeah. So, but just to kind of translate that, what we're saying or what we've interpreted, or what Martha has interpreted as the language around respecting an establishment of religion, like you said, it's not just about the act of establishing religion or endorsing religion. It's making the motions, making the moves that could lead to something like that
Right.
is problematic. And that's sort of the interpretation of Congress shall make no law respecting, right? And that to me, that's a fascinating argument, man.
Right. And it doesn't seem today to have as much weight as perhaps it has had in the past.
Yeah, where has all the respect gone?
I mean, that's a bigger question. Speaking of philosophical questions. But like that was a big part of the Lemon Test, right? Because the Lemon Test, you alluded to the Lemon Test 3 question. Was there secular purpose? Did the law have the principal or primary effect of advancing or inhibiting religion? And then does it create an excessive entanglement between government and religion? So like that entanglement question was very much about like, hey, does this get us too close to the establishing line?
Mm-hmm.
And so, but Kennedy versus Bremerton, boop, we got rid of the Lemon Test, right? And so now we've got history and tradition. And so we have to analyze these things based on historical practice and understandings. And as you can probably guess, that has a couple of issues when it comes to public education. The first of which is public education wasn't really a thing at the time of the founding. So when we adopted the Constitution, public education was pretty much non-existent in the United States. It didn't come around until, the mid 1800s. So we don't really have historical understanding or practice of religion as applied in education to fall back on because there wasn't any, or at least public education, right? There was private, and private education was completely religious in some situations.
Yeah. So in other words, what the government did at the time of the founding is very different than what the government does after. At least with respect to public education,
right?
50 years later, 75 years later, what the government does. So they might not have had any concept.
Right. They weren't thinking about how the Establishment Clause applies to schools because they weren't public schools to which to apply it.
Yeah.
And then the other big challenge here, and this is one that like, it's going to be so hard to unpack. Public education and religion in the United States have a very complicated, intertwined history.
Totally.
Like when public common schools were growing in popularity in the mid 1800s, Horace Mann, who is, often treated as this like pivotal figure in the history of American public education, he advocated that any good education necessarily included non-sectarian Christian religious and moral values. So like, that's why we have so many Catholic private schools, is because the public schools were predominantly Protestant.
Yes.
And are like, included Protestant teachings.
And the
like,
schools
there was
that
a disconnect there.
Right. And the schools that were around at the time of the founding were religious for the most part.
But these are public schools that now are like.
Right. But I'm just saying like the schools that the development of public schools were based off of were largely religious, right? Like that was what schooling was.
And they maintained some of that religious character for sure.
Totally.
And it wasn't until like, the early 1900s where like people were like, hey, you know what? Maybe we should roll this religion stuff back a little bit.
Yeah.
And so like, if we're looking at historical practice, that could justify a lot of policies and practices that we would find really problematic today.
Exactly.
So like, there's so many challenges if we're looking at history and tradition in the context of religion in public schools. That being said, that's the test. So let's apply it.
Well, if we're going to, I just want to say, if that's, if this is the test, it feels like this is going to get a lot worse before it gets a lot better, right? It's going to get a lot messier,
right?
Because that test, that history is messy,
right? And courts are bad historians.
Well, some courts don't think that they are.
Well, maybe that is my perspective. Right. So we've got to, so basically the court here like acknowledges that like, hey, we don't have a history of religion and public education at the time of the founding. So we got to do something else.
Okay.
What we do have though are telling traits of what constituted an establishment of religion at the time of the founding. So we can just basically use reasoning by analogy to see if the current practices of teaching Islam violate any of those telling traits. And so the court basically treats these telling traits. Ooh, say that 10 times fast. The court basically treats these telling traits as a checklist.
Okay. And these are the same kind of
they're
traits.
Very similar to the ones from Nathan. Yes. Yeah. So, so they're almost identical. I think they come from the same sources, but they're slightly rephrased, which is actually kind of interesting. And we'll unpack that when we talk about Nathan, I think.
God.
I know you're ready. But you ready for the traits?
Let's go.
So these are the things that we are weighing the teaching of Islam against, okay? So first, one of the traits, the government exerted control over the doctrine and personnel of the established church.
Okay.
So not an issue here, right? Like we're not telling anybody who's part of a religion what to do.
Right.
Second, the government mandated attendance in the established church and punished people for failing to participate.
Okay. Yeah.
This one maybe because
You're
mandatory
mandating
attendance, like
yeah.
we're mandatory belief. Maybe there's a coercion aspect here.
Yeah. And if you just decide to skip that class because you don't agree with it, you could fail that
Right.
test,
There could be
right?
punishment.
Punishment.
Yeah.
Right. Yeah.
Right.
Okay.
Or consequences. Yeah. Third, the government punished dissenting churches and individuals for the religious expression. So like maybe not.
I don't, yeah.
The government restricted political participation by dissenters. So if you're not part of the religion, you can't be part of the government.
I
Not
don't think that
an issue
applies
here.
Yeah.
The government provided financial support for the established church, often in ways that preferred the established denomination over other churches.
Oh, well, the first part, yes, because it's the curriculum and they're paying for the materials and the blah, blah, blah. The second part, are they doing it in a way that prefers it over others? Potentially not, because you're not just only teaching about Islam in there. You're teaching about all these religions, right?
Right.
So,
Yeah.
Okay.
And then the sixth one, the government used the established church to carry out certain civil functions, often by giving the established church a monopoly over a specific function. That one is really interesting if you're thinking about a religious charter school.
Yeah.
Because the government used the established church to carry out certain functions. If the government, so basically that one seems to suggest that a religious charter school might violate this new history and tradition test because the church would be running a public school.
Exactly.
Right. So interesting, like that, you know, we talked a lot about the Oklahoma religious charter school cases, right?
Right.
Just an interesting one because that's another one that gets wrapped up in all of this like reimagining of the religion clauses.
Oh, man.
I know. Isn't this so?
No,
I was gonna say
like if your
fun.
head is spinning and you're like, I need a drink.
We need we need flashcards with all of the religious tests and cases on them.
Yeah.
But so based on those traits, Hilsenrath is arguing that, you know, teaching Islam violates two of them. First, that mandatory attendance in established church. She says that that's basically what's happening here because the school is indoctrinating students into a particular faith. So they're forcing them to be exposed or forcing them to accept certain religious doctrine. And what's interesting here is like, it doesn't say coercion, but the Supreme Court has been very clear, even in the Kennedy case itself, that coercion is one of the foremost hallmarks of religious establishment.
Right.
So if we've got coercion, that's a big problem.
Right.
And, you know, that's what Mom's arguing here is that like, this is coercive by teaching Islam the way you're doing it, the videos you're showing. And the court says, you know, hey, context is everything here. The court actually says context is key, which feels like a good chalk and gavel-ism.
Oh, yeah. Let's put it on some merch.
Let's do it. Maybe a key ring. Hey. Hey.
Nice.
That's good. Write that down.
Yeah, I'm going to write that down.
If only we were, you know, maintaining our conversation for posterity right now.
I know, right? We should record this.
We should. But the court said that nothing here about the context showed that the court or the school was engaging in any sort of impermissible proselytizing. Like this is purely about learning about religion, not promoting it.
Okay, that makes sense. Yeah.
And, you know, the second argument that Hilsenrath makes is that the law was essentially non-neutral because it emphasized Islam over other religions. So that was kind of like that idea of like financial support. Right. And the court basically says like, number one, we're not sure if that's still a requirement under the Establishment Clause that you have to treat religions alike and you can't, you know, whether or not there's this like non-neutrality principle anymore in the Establishment Clause. Right. And so they said like, even assuming that there is, like, there's no evidence here that Islam was treated any differently than any other religion. So there's no favoritism here.
Great.
Mom
Yeah.
Mom doesn't win that one.
Okay.
So because what the school was doing doesn't look anything like historical understandings of an establishment of religion, there's no Establishment Clause violation, and the school can continue to teach about Islam. So that was how the court decided this case.
That's really, it's interesting because, again, as these courts are no longer using lemon, the question is something going to trigger a violation under these new rules? Right. And in this case, which is interesting in light of the Wood versus Arnold case, which is pretty much identical, that used lemon and said, school, you did nothing wrong. This case used history and tradition and basically ended up at the same place.
Right.
Okay. But the 10 Commandments thing, on the flip side, under lemon, bad move.
Right.
Under this,
Stone said you can't do it.
Right. And under this new set of rules, they're saying, it's totally fine. I mean, that's only one court's opinion that it's totally fine. But like you see, like this is some messy stuff, man.
Right. Yeah. So like the new answers are not the old answers, and they could be different, right? So like you've already identified, we have two historical cases that came out differently because of
the different tests,
the new tests. Yeah.
Yeah.
I do agree, though. We need a better name for the history and tradition test.
What should we come up with?
Because it's lemons, I immediately went to like apples and oranges, because like it's apples and oranges, right? Like history and tradition has very little overlap with what the lemon test was asking, even though the lemon test was based on the court's prior understandings of the Establishment Clause, basically just try to synthesize it all together.
Well, let's come up with something. Listen,
maybe that'll be the homework. Context
is key. That's a big one. We've got one big one for the episode. We'll come up with something big.
That's our quota. We can't be asked to be more creative than that.
I know.
But I think that's a good idea. Yeah. I think that's a good idea for the homework. If you can come up with, if you, dear listener, can come up with a better name for the new Establishment Clause history and tradition test, we would love to hear it. And maybe it could become a new chalk and gavelism.
That's right. We'll give you a shout out on the show.
Yeah. That'd be fun.
Yeah.
So put it on social media. At Chalk and Gavel, you can find us on social media. Put it on the feedback form. Send us an email. We'd love to hear from you. Check out our website, chalkandgavel.com. Huge shout out to Andrea Morris, our research assistant, for all of her help in preparing today's episode, and for all of the other work that she's doing for us. We need all the help we can get.
That's right. Okay. Well, there you have it. It's a mess out there. It's a mess.
But we'll help you through it.
One every 2 weeks
at a time.
Yeah, that's right. All right, everybody, have a good one, and we'll see you again in 2 weeks. Bye.